right, we're live.
Do it.
We can do it.
Whenever you're ready.
Go for it.
All right, we got a class just busting up the seams today, so we're going to talk about estate and trust sales and kind of what you need to know, just a little bit about, if you guys find yourselves, and you will, find yourselves talking to somebody and they're interviewing other agents, hopefully I can arm you a little bit of knowledge. So you guys know what you're talking about and can sound like, you know how to do this process. So I've done quite a few estate and trust sales, and there is a difference between the two. So let's start with that. When someone says their property is in a trust versus someone saying this is an estate, realize that when someone says the property is a trust, that means before they passed away, they had went through the process of going through what they call probate. And that means that the attorneys have and the judges have already declared who the rightful heir is and who the executor who can sell the property, okay? If it's an asset of an estate, we have a clause, I think it's number 15 in our purchase agreement, that outlines court approval. It just says that the property is an estate, an asset of the estate, that it is subject to the courts approving the sale and issuing a court officer's deed. If you find yourself in that situation, basically what they're saying is that that purchase agreement has to go in front of the courts. The courts have to approve the sale, and they also have to open up the estate, and they deem through the court officer's deed who is the rightful heir, either through will or joint tenancy, or whoever has the legal right and the authority to sell the home. Okay? Now, some things that you can offer as an agent is, first of all, to maybe to align yourself with an attorney that specializes in trusts and estate sales. Okay, some people have not gone through this process, and when they die and then they decide who the rightful heir is, that estate will need to be opened up. And you can help direct them to an attorney to help them do that. It usually takes about 30 to 60 days. 30 days is the low side. That's an attorney that really knows what they're doing and is really pushing it through. 60 to 90 days is probably more common. There are a lot of attorneys at Wasker law firm. They're a real estate attorney, as we all know. They have people that obviously know how to do estates and trusts. They do everything real estate related. Ross Barnett, who's with Adamdroth and Russell, kind of specializes in estates and trusts and things like that. So definitely align yourself. Make sure you have yourself somebody who you can turn your clients to get that, someone who knows what they're doing and knows how to push the thing through the process. Another thing you can do to help yourself a little bit is, like what I've done is, I know a few people who do auctions, and when someone passes away, they obviously leave a lot of stuff, and there's a lot of stuff in the house, and a lot of times they'll have an auction. Once the family has sorted through who gets what and who wants what, there's still a lot of stuff left over. So you can align them, you can introduce them to someone who specializes in doing tag sales and stuff. Typically, someone who's in that profession has a huge list of email list of people that they network with to get people to that auction, to that sale. And that money, typically, whether it's cars and furniture, will all that money will go into the estate with the attorney that they're using. Okay, and the estate will be settled once all the assets are sold. Okay. Now, what I've been seeing a lot lately is people are living a little longer. They're going to assisted living. Maybe they have dementia. Maybe they have Alzheimer's. And if that's the case, their daughters, their sons, their whatever, they're selling the property on their behalf. Now, these people are still alive, so it's not an estate, it's not a trust or anything like that. They're operating as a power of attorney. And what you'll need when you sit down with them is you will need the original copy of the power of attorney to get to our back end, the services center. And you will need a letter from their physician that shows that they are mentally incapable they're not a sound body and mind, but basically, and of course we all know to sign a contract, that's one of the conditions, right? They have to be a sound body and mind. So They act act on their family's behalf as POA, and then we need something from their physician saying that they're suffering from Alzheimer's or dementia and unable to make sound decisions. Does that make sense?
Mm-hmm.
So, again, to recap with the estate stuff, if someone dies and the property is the asset of an estate, they will need to get an attorney to open up that estate. And opening up the estate is just the courts identifying who has the legal authority to transfer property. Now, just someone and this is something I just learned, that just because someone is the executor of someone's will does not mean they were given the power of the sale. Okay? Now, typically they do give the power of sale to the executor. That means that executor can make all decisions as far as the will and everything, as far as the assets are concerned. The judges still have to approve the sale. They're making sure, because just the executor sometimes, if they're in charge of making the decisions, but they're not always the only beneficiaries of what's being sold. In fact, what you might find a lot of times is the executor has no stake in the beneficiaries. Meaning they are not receiving an inheritance. They're just acting as, they appointed them because whatever they felt they were the responsible one. All right. You'll also find every now and then that there are, let's say there's 2 brothers and 2 sisters, and they're all part of the benefactors of this estate, or the beneficiaries of this estate. A lot of times they don't get along. We all see that. Death sometimes can bring families together, and sometimes it can split them apart. And more often than not, it kind of splits them apart. So I'm dealing with one now where 2 sisters and the brother, they don't get along. The brother, the older brother, he's the executor. He's the only executor, but he wasn't given power of sale. So what that means is that the courts have to approve that sale. The sisters, the brother, they all have to come to an agreement that it was sold for market value, okay? And that's really what the judge is trying to determine when they're looking at the sale, is that it was sold for close to market value. That there isn't an executor in this situation where he's looking at his 2 sisters and saying, I'm going to get over on you, I'm selling this at a huge discount because I don't need the money, I know you do, I don't like you, we're selling, The judges make sure that doesn't happen. The judges make sure that the home's being sold for fair market value or close to it, okay? So just make sure that when you do sell an estate, that you go over that clause. And I might be wrong, that it's point number 15, but it's at the top of the last page. And it goes over court approval. And it says very specifically that this agreement is, because it's a contingency in the offer, that it is contingent upon the courts approving the sale. If the courts come back and say, sorry, it's not approved, that buyer has the right to cancel their offer and get their earnest money back, and so does the seller if they can't reach an amicable agreement on price that the court said, okay? I have never had the courts come back and tell me that they didn't approve the sale, but when you have people that are not getting along with each other, you're probably more susceptible to that happening than if it was just one benefactor, one executor, that kind of thing. So, when you do walk into people, again, let's cover the POA again, the power of attorney. It's not a mistake. Someone has not passed away. But it's kind of handled the same way. I mean, there's a lot of stuff in the home that needs to be sold. Become an asset to the process by introducing them to people that can help them. Whether it be movers, whether it be an auctioneer, whether it be the attorney. Become an asset to the process. So when I walked into this house the other day, it was the same situation with the POA. I was the one that was asking for the original power of attorney. I was the one that was asking them for the physician's letter. They already knew they needed it because their attorney advised them on it. But the other agents that I was competing with didn't. So I won the listing just simply because they felt like I knew what I was talking about versus someone who didn't. So, or actually 2 or 3 agents that weren't quite familiar, or at least didn't voice their knowledge and let them know that, hey, I've done this many times before and this is what we need. So the 2 people sitting in the class, have you guys both dealt with estates?
Once.
once. Was it a pretty easy process
It was.
for you? Yeah, a lot of times you might not even get to somebody till the estate's already been opened. Like it's ready to go. I mean, they've already deemed this person has the right to sell the property, and you're listing it, and it goes through smoothly. But if you're getting somebody at the beginning of that, you list a home, and as hot as the market is, you have to realize that you might be a 90-day closing. I mean, it might be 30, 60 days before the courts open up the estate and deem who can sell it. Then you start the loan process, okay? So if you had your way, you'd always like to try to see the seller get through some of that probate, as they call it, probate. You'd like to get through that probate prior to listing, or at least almost all the way done through it.
It takes at least 30 days.
What's that?
At least 30 days.
At least 30 days. At least. That's an attorney that really knows what they're doing, and they're really pushing it through. So you're looking probably more like 60 to 90. And again, every situation is different because of the heirs. You know, you might have one executor and there's 8 other children. You know, if that executor was getting power of sale, they really don't need to consult the other children for the sale. The courts just need to approve it. But if they weren't given power of sale, then everybody needs to be in agreement. And you guys know how hard it is to get 2 people to agree on anything, let alone eight different people. Someone always feels like they're being slighted or whatever, you know, so, or I'm not selling the home for high enough or something like that. But yeah, the more heirs, the more beneficiaries, typically the harder it becomes because you're trying to satisfy a lot of different people. But the executor is who you need to be working close with. That's who needs to list the property, that, you know, or someone who has the POA. And it's not always just one person has power of attorney. When you dealt with this person, maybe it was the daughter and the son. So you need everybody who's if you got 2 people who have power of attorney to sell the home, and both people need to sign the listing agreement, both people need to sign the purchase agreement, okay? If you have 2 different executors, which is uncommon, but it does happen, they both need to sign the listing, they both need to sign the purchase agreement. And they sign them as, let's say, Rick Herron as POA, or as POA for Matt Morrow, right? Or Rick Herron as executor of Matt Morrow Estate, okay? That's how they can sign their name, but underneath it, that's what you need to put. And then when it goes to the seller up top, that's what you put, Rick Herron as executor of Matt Morrow Estate. That's who they're making the offer out to. Okay, now a lot of people will ask you for tax advice, and you really should refrain from giving it to them. Now you might want to have an attorney or an accountant in your back pocket that can advise them, that you can give that to them. But there's a lot of tax implications when it comes to selling an estate. Okay, when it comes to inheritance taxes and things like that. Okay, and some people are exempt from the inheritance tax and other people are not. What you will see, and you'll see people that are living do this, they'll say, well, Dad's 92, he just added me to the deed. And again, I don't want to give anybody any tax advice because laws change and I'm not a tax attorney, but that, from what I understand, that is the absolute wrong way to go about it for tax implications, okay? Basically, by doing that, when that son sells Dad's property, he's liable all the way back from what Dad originally bought it for. Okay, and everything in between. So if you have a house that's been in your family 100 years and they paid $4,000 for it back in 1932, and it's worth $180 now, that's a lot of tax liability, right? So seek out a good tax attorney or a good accountant that can advise your peer people. As real estate agents, we're all about being connected and being, you know, we just like someone has an HVAC problem, you have somebody in your back pocket. Someone needs flooring, you have a flooring guy, right, or a roofer. You need to have an attorney and you need to have an accountant that you can turn these estates and people over to when they don't have anybody, okay? Now, the worst part of this is when someone dies without a will, right? Because there's no rightful heir. And if you guys remember, there's a word in real estate that's probably the nastiest word ever, and it's called cheat. Do you know what cheat means? Remember? That means someone died without a will, and their property, there's no direct heir that they can identify. Therefore, that property goes to the state. It's called cheat. is cheats to the state. That is something we all want to avoid personally, and you make sure you advise the people that are in your circle to avoid that, you know. So, yeah, you want to have, even in your personal, you want to have a living will, you know, to make sure that everything goes down the way it's supposed to. And you think, well, you know, Rick's been married for how many years? 40 years? Close, 38. So, you know, you think, well, if I go, my wife's going to get my stuff, and then, you know, she's not getting it. What happens if you go together tragically in a car wreck or something? You have your rightful heirs in place.
Go to my girlfriend.
Yeah, go to your girlfriend. Which he's outlined in his will. So, but, you know, you want to make sure that those things are set up for your children and your grandchildren or whatever. So the older you get, the more you accumulate, the more probably in your savings, the more in your retirement. You set those up for your IRAs, and if you own properties like I do, things like that, you want to make sure everything goes down the way it's supposed to. Name an executor and things like that. So become an advisory for your clients, and make sure you have the connections to give to them to put them in the right spots. Okay, so not just any attorney will do. Some attorneys specialize in corporate litigation. Some of them specialize in, you know, slip and falls and that kind of thing. And others specialize in real estate. Some of them specialize in accounting and, you know, tax attorneys. And some of them specialize in real estate. You want to get yourself someone who specializes in real estate. Okay. And Ross does a good job. Ross actually really does specialize in estates. And Dave Pulliam does a good job at Lasker. Joe Hall, all those real estate attorneys that we deal with every day, this is part of their job. We don't see that part because we're always on the title opinions and the closing side of things. But these attorneys that specialize in real estate, that's part of it. That's part of their everyday life. So they know how to set you up, and they'll thank you if you get them with somebody who's good, knows what they're doing, and of course a good person. They'll thank you for setting them up with that, and it'll be easier. You might get referrals from our attorney. You know, that's another thing. How do I go out and specialize in estate and in trust sales? Well, there's two people that get to them before us: funeral directors and attorneys. So, you know, you can market that angle if you want to. You know, get all the real estate attorneys on a list and send them something every month, and donuts and things like that out of their offices, and just like you would attack any other line of the business. But it certainly is a line that a lot of people don't focus on. That's why I kind of went after it. You know, I like estates. I like old stuff. I like, you know, someone that has a 1920, you know, like record player. I think that stuff's cool. Also, older people.
You're trying to be a beneficiary.
Yeah, right. Well, it actually has happened quite a bit through my career, where it's like, well, no one wants this old antique hutch. Do you want it? Yeah, I want it. You know, and take it. You know, so you know, a lot of times you will get stuff that's pretty cool just because by default no one wants it and you can get it out of there. But you know, I own a moving truck. I know not everybody can do that. That helps too. When I offer that up, you know, say, hey, you guys can use my moving truck and haul away stuff that wasn't taken to the dump or whatever. That helps add a little bit of value onto the process. But I think just really knowing what you're talking about, knowing just enough to be dangerous, knowing what you need to make it happen is key when you're going in talking with somebody about this type of deal. And just keep in mind that, you know, there's a lot of emotion. And sometimes there's not. Sometimes there's not. Sometimes the guy lives in California, the home's here, it was mom and dad's house they bought because they were older and got in that ranch. There's no emotion at all. He doesn't want to take care of it. He doesn't want to mow the yard. Your time's worth 150. He tells you listed at 140. I want it gone tomorrow. You know. But other times you're dealing with people who, that's their family home. That's where they were raised. That's where they had their Christmases. That's where they brought their, you know, the youngest kid home. That was a baby. That's where they brought their grandkids. There's a lot of memories there, and it can be tough and it can be emotional. And you need to be, you know, it helps to be sensitive to those emotions. And everybody, you know how to deal with people, and I don't want to teach you how to deal with people, but just recognize that those emotions can be there, and I would handle it accordingly. You know, walking through the home, and it always helps to empathize. You know, I mean, I just sold the Mauro house that was in our family for, you know, getting time basically. It was always our house. And it was tough, man. All 9 kids were there, all 31 grandchildren, spent a lot of time there. And, you know, our aunt passed away, Sister Joanne passed away last year. you know, there's nothing to do with the house but sell it. But there's a lot of memories there, and even as just a grandchild, it, you know, was tough to see it go. A lot of stuff to sort through. Who wants this? Who wants that? You know. So, but you'll get into that, and just if you've had some experience with it, you know, like your own emotion, it helps to empathize with people. Not just be sympathetic, but to actually empathetic. Where, yeah, I've been through this myself before. I know what you're going through, and I know it's tough, and you know we'll take it slow. It's not have to do a quick sale. But, this really isn't a long class, but if someone does put their property in a trust, just realize they've already gone through the probate process. You don't need to do that. So if I'm selling, you know, Rick's house and it's a trust, Rick Heron Trust, they've already gone through the probate. I don't need the course to open up the estate. If they've already done it while they're living. And if you do have older people in your life that are aging and that are even sick, that might be something you want to advise them to do, is go ahead and just get it into a trust. You know, older people tend to do that anyway. So, we definitely don't want to die without a will. The property is an asset of a state, has to go through probate. If it's an asset of a trust, it's already been through probate. And then if we're acting as a POA, remember we need the original POA and we need a letter from the doctor or physician. Now, if that person's not suffering from dementia or Alzheimer's and they are of sound body and mind, they should be signing the purchase agreement or the listing agreement. They should be involved, okay? Because I don't know if acting as power of attorney alone, someone can sell that without that physician's letter. The last 3 that I've done, they all needed physician's letter saying they're not of sound body and mind. So if they are, the physician's unwilling to do that, they need to be involved. Because sometimes older people, they think they're going back home. You know what I mean? They still have hope. And the kids are more realistic. So they have POA and they're going to sell mom and dad's, they're going to sell mom's house. Well, mom is just family physically, but she's all right here. That might not fly. Okay? If she's all right in the mind, that might not fly. That's still her house, regardless of whether or not the kids think she should sell or not. So, your estate, anything happened unusual that didn't go through?
I was on the buyer's side, and it was so smooth because the seller was deceased, but she had no children. The lady that owns Legs on Lease was the executor. She was also coordinating all the tags. I mean, we needed court approval, but it was.
Gotcha.
It was
so
smooth,
the court approval, again, the court officer's deed, what it's doing is keeping the chain of title intact. So when the courts open it up and say, yes, you have the legal authority to sign this court officer's deed, and they can't come back to the abstract and say there was a break in the chain of title. Okay? You've been through some estates and stuff, haven't you? And you've had a long careers, so I'm sure you've seen it. What was your experience like? Anything happen that was messed up or threw a wrench in your plan?
Well, I've had people tell me that they're a trustee and it hasn't even gone through probate.
Yeah, you'll see it recorded as a trustee on the assessors if it's
Just want to
recorded.
make sure that you see all the paperwork.
Yes. Yeah. And remember, some people think they know what they're talking about, and they have no clue what they're talking about. They just think they do, and they're misinformed, or there was some kind of miscommunication along the way in the information that's coming down. And this just happened, you know, in Norwalk. Guy had executor, right? He thought he had all the right in the world to just sell the home. And, well, he didn't have power of sale. So power of sale is big. If you guys are setting up your own estate, or those that are listening from their desk, you're thinking about, oh boy, I better get my own will and get my own estate going. Make sure your executor has power of sale. I don't think you want people fighting over your estate or one executor trying to make 4 or 5 different people happy. You know, trust. If you name an executor, obviously you're trusting them to make the right decision on your behalf, your family's behalf, or whatever. Give them power of sale so it makes it easier on them, so they can pull the trigger on what they feel is right for you, for your heirs, and you know. So, if anybody's online and you have a question and want to type it in, do so now. Otherwise, it's going to be a pretty quick class. You're always free to ask me anything, to contact me directly. I've been through probably 3 dozen, if not more, estate sales, so, most of them go through pretty smooth with the right preparation and, you know, and the right attorneys involved, so. Anything else? Becca, you have anything?
No question.
Rhea? Rick? All right, this was a quick class, but it definitely is a way, and it's another line of business you could go after. And not a lot of people seek it. You have to be very strategic about it. I mean, you know, when people pass away, obviously it's a very rough time for people. So timing is everything as far as being able to get in front of them. But I would definitely talk to the estate attorneys that you know and things like that, and let them know that you want the business and you're familiar with estate sales and you can be an asset to the process. So on that note, we'll adjourn.
Thank you.
Hey.
So yes, under 30 minutes.